ahead. Okay. And
Good morning. I
we'll
did
let you.
not have the opportunity to sign up to speak this morning. I would ask for your permission to proceed today.
Please do. Thank you.
My name is Allison Coyle, and I'm an attorney here in Little Rock and Russellville. Since the recent December 2016 Arkansas Supreme Court ruling, I've been hired by no less than 5 same-gendered couples to complete the process of a second parent or step-parent adoption. These couples are hardworking, tax-paying citizens of this state. They are employed in all different sectors, including the armed services, the police force, and their federal employees. They represent the best this state has to offer, and through the process of artificial insemination or surrogacy, they've conceived beautiful children of all colors, genders, and ability. However, from the moment these children are born, they and their parents are immediately treated differently than children born through the same means to opposite gendered couples. This unequal treatment must cease, and now is the time for the Arkansas legislature to address the problem and correct this inequality. Regardless of your feelings on same-sex marriage, a yes vote for Senate Bill 580 is a yes vote for an equal application of the law. My firm has worked out a reduced rate for these families that have contacted us to supersede some of the issues that this lady over here has presented before you today. But even then, these couples can spend between $1,000 and $2,000 in costs and related fees to complete the adoption and have their children's birth certificates changed. Some couples I've spoken with have paid as much as $7,000 in attorney's fees and costs. This practice must now stop. No attorney, myself included, enjoys taking people's money, regardless of what some people may think, for something that they could and should be changed by the Arkansas legislature. These couples should be putting their hard-earned money towards college funds, paying medical bills, or otherwise improving the lives of their children. Instead, Arkansas finds itself as the only state in the nation which does not currently recognize same-gendered parents on a birth certificate from the moment of birth. I ask you to consider this. What happens when a child is hospitalized before the adoption process is complete? Perhaps the non-listed parent has taken the steps to adopt their own child, but they have not had the adoption process finalized. Our courts are busy around here, and as some of you may know, it can take months to have a hearing placed on a court's docket. These parents then find themselves in the unenviable position of legal ambiguity. The non-listed parent could be turned away from their children's medical care providers or schools. Or consider this, perhaps only one parent is listed on the birth certificate and the other non-listed parent passes away. It's possible that the child cannot inherit under the laws of Arkansas as they are now written. Senate Bill 580 changes this position today. The adoption process also takes up the court's valuable time. I've even had judges say that they should be spending their time on other types of cases rather than having to hold a hearing and produce an order for something that could have been and should have been resolved already. A yes vote today on Senate Bill 580 would resolve these issues by automatically recognizing the parent-child relationship between both parents and the child from the moment of birth, just as the law currently reads for opposite gender couples. By changing the wording of this one statute, the Arkansas legislature will be treating same-gendered parents as their opposite-gender parent counterparts. Now is the time to act, and now is the time to correct this inequality. I stand before you today to ask for your vote in favor of Senate Bill 580. Let's let these parents move forward as a family unit before the child or children leave the hospital. This is what is right, and this is what these families have prayed for. Thank you for your time.
Thank you very much. And you're an attorney, correct?
I am here.
There are other legal ways to make sure that children inherit their families or friends' belongings. Isn't that correct?
You are correct. There is a probate process that can be undertaken, but again, that does occupy the court's time when there are other ways that these children could inherit automatically.
There are wills and gifting that you can do, so there are other options, correct?
That is correct. There's also trust, but these are all expensive options.
As would be if you were the child of someone, they're all options. They're still out there though, correct?
That is correct, but inheritance as a right is guaranteed for children that are recognized by the state.
Okay, thank you. And is there anyone to speak against the bill? Mr. Calvert, you're recognized to be brief. Thank you.